concerned citizens and NGOs fighting these cases were probably kind of conveniently portrayed as being busybodies, as people who had nothing else to do with their time but to bring those cases to court. For the little story behind that, when I accepted to take on this issue of locus standi, I did tell my clients, I said, okay, we're gearing up now for the Privy Council. Yeah, I think you are heard for the merits of your case, and then you are presenting your case before, judges of the UK Supreme Court. So in terms of standard and expertise and knowledge, you're really dealing with la crème de la crème.
Hi everyone, I've got a small favor to ask. I know that many of you have been watching these conversations over the past couple of years with people who inspire. It would mean a lot to us and it would help us continue to have these conversations if you would just subscribe to the channel. Thank you. Anne-Sophie, thank you for accepting my invitation.
Thank you, thanks for having me.
Anne-Sophie, I know you as a bit of an expert in arbitration, but we're not going to talk about arbitration today. I wanted to have you as a guest on the podcast to talk about Ecosud, rather the Ecosud judgment, which for those of you who are not familiar, I think it's fair to say it's a landmark judgment in environmental law. And we're all the way to the Privy Council, and we're gonna talk about that just in this podcast. But I guess the first question I had for you is, where does environmental law come into play in your professional life? When did you start doing it? Why did you start doing it?
Yeah, I think it's a fair question because, I think when you practice in international arbitration, when I first started more than 20 years ago in London, there wouldn't be really an overlap between arbitration and environmental law. Things are changing now. Actually, we are seeing an overlap now today. But in those days, it wasn't the case. So actually, I had absolutely no knowledge or expertise in that field until quite recently, in fact. And what brought me into getting interested in working on these cases was, I think, two things. First was, I think, a willingness to make a change in my country when I came back to Mauritius 10 years ago. I think I had a bit of a culture shock professionally, seeing the gap between the way things were done in London where I was practicing and in Mauritius, and also seeing how conservative I think the courts were in terms of interpreting the law, interpreting our constitution, etc. So I really wanted to get involved in, be it human rights or environmental law. And then I think an opportunity came along. It was the case of the fish farm there was a fish farm that was intended to be developed on the west coast of the island. And there was a need for legal assistance on this. So at the time, I didn't know anything about environmental law, hadn't been before the Environment Tribunal. But as lawyers, I think part of the skills that we acquire is to be able to work in new areas of law. So I took on the challenge, and it's been about 10 years now that I've been doing these cases and working on other things as well in that field.
And what would you say is, what do you find challenging? And what do you find positively or negatively about practicing, I would say, in some ways, an emerging area of law?
Yes, I think the challenge that we had until the Ecosud judgment in 2024, the challenge that we had was that to be able to make a change, you first need to have a voice before the Environment Tribunal. And we couldn't open the door of that tribunal because the manner in which the courts or the Environment Tribunal was interpreting the locus standi test in those days was very restrictive. And locus standi in layman terms is the test that is applicable for deciding who is authorized to bring a challenge before the Environment Tribunal, as you know. And the test that was in the Environment Protection Act was interpreted very restrictively. So the first challenge that the clients I represented, citizens or NGOs and others as well, and us as lawyers, was that there were some very worthy cases to bring to the tribunal, but we couldn't really proceed on the merits because the cases would be dismissed simply on the ground that we did not satisfy the locus standi test. I think that was the first challenge. And then secondly, these environmental cases are for the most part quite technical and burdensome. So it's not your everyday small case. It requires expert reports, many days of hearing of evidence. So I think that is also something maybe that puts off a lot of people from taking on these cases, because it is a lot of work, and when you get into it, you have to be prepared to put the effort that it requires. Most of the time, these cases are not funded. There might be some funding from time to time, but you go into these knowing, or at least not on the expectation that you will be funded. So I think that's a third difficulty that we had to face, because a lot of the time you don't have a team with you and you are against big teams, the legal team of the promoter, the legal team of the Ministry of Environment. Often the Ministry of Fisheries is also involved. So you have a team of 12 lawyers and you're kind of on your own with no help. So I think these are the main difficulties that we had. And then maybe a lack of respect, maybe I would say. I think until the Ecosud judgment, concerned citizens and NGOs fighting these cases were probably kind of conveniently portrayed as being busybodies, as people who had nothing else to do with their time but to bring those cases to court. And I think the Ecosud judgment has given credit and credibility to those people ultimately who were the only one, going forward to do the job that the Minister of Environment ought to have been doing during those years. So I think these are the main difficulties that we had to face, and leading to the Ecosud judgment, I think it was a big relief to see finally some change coming through that case.
So before we get into, because Ecosud, if I'm not mistaken, the Privy Council judgment concerned, if you will, a point of procedure about the locus standi. But I think, and without going into too much detail on the merits as such, because the case, I understand, it took a different turn, but underpinning it, obviously, is the environmental issue. And I understand that part of when you're implementing any new project that could have an environmental impact, there's a need for an EIA, environmental impact assessment. What is it and why is it important?
Yes, so the litigation up to now before the Environment Tribunal in terms of environmental law has been mostly EIAs. So the way EIAs work is that the law provides for a list of types of projects which are presumed to have a certain level of impact on the environment. And because they are presumed to have a certain level of impact on the environment, the law requires as a mandatory condition to proceed with the project that the promoter obtains a clearance from the Minister of Environment. So until 2024, because 2024 was the enactment of a new law, but until then we had two types of listed projects. We call them undertakings. They are not called projects, they are called undertakings. So we had projects requiring a preliminary environmental report with minimal presumed impact, and then those with a higher presumed impact required EIA licenses. And now with the new law, which was enacted in 2024, we also have a new types of licenses, which are strategic environmental assessment licenses. And this is quite new, so we actually have our first case going before the tribunal.
So that's presumably a higher level of...
Yes, so the difference between the two is that for EIA licenses, the promoter is really required to assess the impact of its project in isolation of external factors. So you look at the impact on the project site and on the vicinity of the site. Whereas for SEA licenses, you have to assess the impact of your project in the context of the potential cumulative impact that your project can have, taken into account factors which are external to your project. So for instance, smart cities now require an SEA license because it has a wider impact. Or potentially if there is a hotel in the vicinity, you may be required then to obtain an SEA license instead of simply an EIA license because it has a cumulative impact. So this is what's new and the main difference between the two. So the way it works is that promoters who fall within the list of undertakings prescribed under the law need to make an application to the Minister of Environment for an EIA license. Once the EIA application is published, the public has 21 days, about 21 days usually, to provide their comments or objections on the project. And then the Director of Environment with its committee need to make the assessment and need to assess the application and in light of the objections. And then the minister or the ministry will make recommendations to the minister, and the minister will decide whether the license is granted. If the license is granted, then any person who satisfies the locus standi test has 21 days to make an appeal before the tribunal. So this is more the process up to litigation.
So as I understand it from when we had an informal chat last week, as regards the locus standi test in itself, that hasn't necessarily changed with the new law. Mm-hmm. But before we get to that, maybe we'll talk about Ecosud first. Mm-hmm. So why are we saying it's a landmark judgment?
Okay, so as I've explained, the main difficulty we had until then was to be allowed for citizens and NGOs to be allowed to have their cases heard before the court. So the difficulty that we had was that the test laid down in the former Environmental Protection Act was worded in a manner which gave room for a restrictive interpretation which closed the door of the Environment Tribunal to the citizen. And the requirement was that you needed to prove that you were an aggrieved person and that you had suffered an undue prejudice. So that was the Ministry of Environment, and usually the promoters were interpreting that in a manner that prevented or that required that you prove an impact or that you were affected in your private right or interest. So it could be an economic right or potentially an impact on your health. So it really had to be direct and something of a private right. So you can see why there was difficulty with that concept when you are in the realm of environmental law, because by definition, we are all impacted by the environment. Everything that we do impacts the environment, yet sometimes the link is quite difficult to establish. So, well, the judgment, this is ultimately what the court had to decide in that particular case, was that the required test, what was the right way of interpreting that test. And we were saying that it would be absurd to impose a restrictive interpretation, because that would more or less have the consequences of preventing people from bringing to the court these cases. And so we were advocating for a liberal interpretation of that test, which would allow citizens, people with some expertise who have some track record or are able to show that they have a particular interest in maybe preserving the environment.
So not just anyone.
So not just, no, it's not anyone. There is a test. The test is not just anyone. You still have to show some sort of credibility in terms of who you are and why you are pretending that you should be able to file this case. And also in terms of expertise, if you just turn up, you don't have an expert, the court is not going to be able to take you seriously. So you might be wasting the time of the court and also causing prejudice to the promoter's project without having any grounds. So the test is not anybody, but it's extremely wide and sufficiently wide to allow concerned citizens and NGOs to bring these cases to court, and that was not possible beforehand. So it's a huge leap, but I think the second aspect of that case, which is important, is that it highlights the duty of care of all citizens, including the promoter and also the authorities, the Minister of Environment, the duty to take care for the environment. There is Section 2 of the former law, which is called environmental stewardship, which is in the preamble of the law. And we were using that section because it does say that everybody must care for the environment. And we were using that section of the law to say that, when you look at that clearly sets out what the purpose of our environmental law is. And if you consider the purpose of the law, you cannot then close the doors of access to the tribunal, which is the tool that will allow you to ensure furtherance and compliance with that purpose. So I think there was a pronouncement on Section 2, which was that despite the fact that it's in the preamble of the law, it is an important section. It almost in the nature of a substantive duty. And I think what will be interesting to see in the future is to see whether that particular section could be used to argue that citizens or the authorities actually have a substantive duty under Section 2. But certainly in this particular case, it was not presented as such, but it was used to present the very wide purpose of the law and to allow for a wider access to the tribunal. And then the third aspect of that case was, I think, the comments made by the Privy Council in relation to the works of the project that had already started. There was no injunction. Ecosud had not applied for an injunction. And what the Privy Council said is basically, if you decide to proceed with the works, you are preempting the decision of the court. And if you do so, then you do it at your own risk and peril.
Yes, because you might have to completely bring down your structure.
Exactly. And the message was that do not think that by proceeding with the works, you will be safe, because the courts do have the power to order that you put back the land in the position that it was prior to you starting the work. So I think there was a strong criticism, but also I think that comment, which was not really dealt with, has not been dealt with at all, I think, in our judgment, really put things in perspective and give a different dynamic in terms of injunction and that particular aspect of real estate projects, really. So I think it's a judgment that, beyond the academic aspect of it, it's really going to have an impact on, first, access to justice, we've said it. Secondly, the participation of citizens in maybe at the very inception of projects, because if you think about it now, with that judgment, promoters are probably or should be asking themselves, well, should I just ignore what NGOs and citizens are telling me about what's wrong with my project from an environmental perspective? So I can either ignore them and then litigate for 10 years, bearing in mind that if you litigate for 10 years, it has not only a huge cost, but that could be fatal in itself to your project, because you have banks financing, investors, etc. And so that could be problematic and mean that your project would have to stop at some point. So they could either take the risk and go into litigation for 10 years and take the risk of losing everything, or they can try to implicate citizens and NGOs from the very start and hear what they have to say and try to implement their suggestions from the very start. It's certainly a safer option, and I think we're seeing a change on that front as well. And of course, more accountability at the level of promoters
and authorities,
and authorities as well. I think previously the feeling that we had, notably when we were reviewing some EIA reports, was that they knew that there wouldn't be anybody to fight, to be able to fight. They knew they were, in a lot of cases, they knew they were going to get their EIA licenses. So the EIA reports were sometimes, not always, but sometimes quite poorly drafted. So I think that's going to render promoters more responsible and also ensure that the authorities finally start to do their job, I would say.
And have you seen that? Because you mentioned at the beginning there was a certain, or at least a perception of lack of accountability from the authorities. With the Ecosud judgment, far beyond just the question of locus standi, are you seeing now there is a real volonté of not just talking about the environment, but a real willingness to bring everyone in from the authorities' side to talk about potential issues rather than just stepping in après le fait when there's an issue?
I think the judgment would have reached a certain result through force, because it's now that test is there and they would in the future have to deal with NGOs and citizens. But the reality as well is that those NGOs are usually not funded. There's very little resources, very few people to fight these cases. So while you might be able to take one worthy case to court, you're not able to take all of them. So there would have been a forced increase or enhanced responsibility, but not necessarily a drastic change. But since the new government, with the change, at least at the level of the minister, we can see the change, definitely. We have, through Ecosud, already made certain requests to the Minister of Environment to act in certain cases in relation to certain projects that we thought required an EIA license, and they've been acted upon. So I mean, it sounds quite small, but for people like, the clients I represent and myself, who've been spending so much time in the last 10 years doing the job that the minister at the level of the ministry should have been doing, this is quite a huge and very welcome change, because we are seeing finally that the minister and the ministry are doing what they are meant to be doing, to do under the law. They have certain duties, and they are abiding. We'll have to see what comes, what comes in the future. But at least the first few months, I think, have been very positive, and it's good because NGOs, have other things to do than fighting in court. So
yes,
and I think as well, maybe the change that we will see. There's also the fact that there is a new Environment Act 2024. Some change arising out of that.
Sorry to interrupt you. I understand that new act was prior to the change of government.
Yeah, it came into force in August 2024, but it will take some time to see, to see some litigation arising out of it. Although we already have a case already in court under the new legislation before the Environment Tribunal. But I think the two major changes in that law. The first one is the new requirement of SEA licenses. The law is, yes, it has its lacunas, it's not detailed enough, it's very ambiguous. Maybe it doesn't really, as a matter of fact, achieve the purpose that it's meant to achieve in terms of SEA licenses, but it's there. It wasn't there before, so that's a big leap in terms of accountability and promoters having to assess their impact on the environment. And then the second important change is the section 30, I think it's 33 of the new law, which makes it a mandatory obligation now for the Minister of Environment to deem certain projects which are not listed. As I've said, there's a schedule of projects, of types of projects that require environmental licenses, SEA, EIA, etc. So if you don't fall under these, usually there's no way that the minister can impose, or that appellants can go to court to say that you did not comply with the law. What that section does is to impose a duty when faced with a project that is deemed to have an impact on the environment, which is material because of the scope of the project, or because of its location, or the type of industry that it's operating in. The minister, so if an NGO goes to the minister today and says there is that project, it's not caught by the list of undertakings under the law, but we think that it ought to require an EIA or SEA license because it will surely have an important impact on the environment. The minister now has a duty to consider that and then to make a decision.
So it has the power to deem a project to be an undertaking for
yes.
the purposes
and once it's decided, that it is a deemed undertaking, then it will have to decide whether it requires an EIA license, or a PR or EIA or SEA license. And the Minister of Environment has already acted under that section already. Notably, Ecosud and others have brought these to the attention of the Minister of Environment, and this has already been acted upon. So that is a huge change, a big change in the new law. And I think the litigation going forward, I would expect to see less of EIA licenses challenges in the courts, because the minister will be finally starting to do the job that it's entrusted to do. But maybe more litigation on the side of SEA, because the law is new, the law is ambiguous, it's not complete, and potentially under Section 30 as well. Strictly speaking, if you request, it's not exactly provided like this in the law, but if you request the minister to abide by its duty to deem a project an undertaking, and the minister decides not to do so, then potentially you have ground to bring this before the Environment Tribunal.
Or it could go the other way around as well. As a promoter of a project, you could potentially say, I don't agree with your decision. I think your decision is unreasonable to...
Yes.
Hypothetically.
Yeah.
It could
the decision under Section 33 is one of the decisions which you can challenge before the environment.
At its discretion, at the discretion of the minister to deem.
It's not actually, no, it's not, it doesn't talk about discretion.
Right,
that's the point.
Right.
It's a mandatory duty. Of course, it's difficult to know scientifically the impact, but the duty is there. Once the minister has taken the view that there is a certain level of impact, and then it needs to deem it an undertaking.
I understand. So. Okay. Well, I'm sure there'll be lots more litigation, which brings me to my next question, which is a point you've highlighted already, which is the lack of funding, which is a big issue. It's an issue for the NGOs. It's an issue for, I would say, anyone who is interested in environmental law. But it's also an issue for professionals like yourself who would either need to do it pro bono or for very little money. So my question to you is, what value, inherent value other than financial, which is a problem, could it bring to a lawyer to do pro bono work or to practice environmental law?
Yes, so I think the first argument in favor is that you're doing something with purpose and you contribute to bringing a change. That, in my view, should be enough. I think as lawyers, we have the means and the tools to help contribute to a change. And I think it's a shame if we don't use it to somehow try to make things better. So that is the first reason. I think the second reason is it's an area of law which is not developed at all in our courts, in our case law. There are very few judgments on that. So I think the world is your oyster when you work on these cases. There's so much you can do. I mean, it often is required to look at what is done in other countries and argue it here before our courts. But there is potential for these type of cases to end up, before the Supreme Court on appeal or before the Privy Council. So particularly for those, looking maybe to beef up their CV or to get involved in more challenging cases, there is certainly room to get involved in cases which are quite, academically challenges and which can lead to some important changes in the law. And I think third is maybe just experience, just the experience. It's quite challenging, but you have to deal with experts, something that you might not be doing in other areas of law. So it's an opportunity as well just to practice your skills and learn new things, to work on cases which potentially you might not be able to do if you were just trying to get them through the normal routes.
One thing you mentioned that I think is so important as well is the sort of the transferable skills as well. I mean, I mentioned at the beginning that you've been practicing or specializing rather in international arbitration for a long time, but I'm sure that even your exposure in environmental law can be of some use, of some value in other areas of law as well. They're not mutually exclusive.
Yeah, no, of course. I mean, the area of law is just kind of the background of the work that you do. Of course, it helps when you have knowledge and when you do that every day, of course it helps, but it's certainly not impossible to do it without doing on a regular basis. And the skills are transferable. So whatever you learn there, of course, is something that will help you in your other cases. And then if you're lucky, you might still end up in, the Privy Council.
Which I'm sure was an amazing experience. I mean, it was your second time, if I'm not mistaken. You had been already by the time of the Ecosud hearing. I think you'd been on another non-environmental related case. But as you mentioned, it has the potential of opening doors that might not necessarily be open if you were just practicing traditional, you run out of the mill general civil law, commercial law.
I mean, for the little story behind that, when I accepted to take on this issue of locus standi, I did tell my clients, I said, okay, we're gearing up now for the Privy Council. I was not actually expecting that we would be winning in the Supreme Court, not because I didn't think we had a case. Of course, I believed in our case, but the trend at the level of the Supreme Court was quite conservative in terms of the interpretation of locus standi in general, be it constitutional, judicial review. There are two trends. So it wasn't really going in the way we wanted it to go. So we were quite pessimistic, but we were gearing up for Privy Council. So when we won first,
there's a nice surprise.
It was a very nice surprise. We still went to the Privy Council, and I think what was enjoyable there is that, which you might not always get here. I'm not saying you do not get, but you might not always get, is when you are there, you are really considered on the merits of your case. It doesn't matter how senior, how junior you are, who you are connected to, and you are there to put your case and they will listen to you. So I think for us, who did not always have that treatment when we were fighting locally, I think that was a big change. And, we were there, we had prepared our case, and the judges listened to us, and we won ultimately on the merits, and this is how things should go. So I think the different dynamic before the Privy Council was certainly something that we were welcoming and that I enjoyed.
Yes, I have to say I was lucky enough to experience that as well a month or so ago. I was appearing against a very experienced English KC, and I really appreciated the fact that we were treated equally. We were equals before the board. The questions were just as tough for each one of us. Tough but fair. There was no question that I thought was unfair or was trying to catch me out. There was no catching out to be done. It was just, put your case forward. We're going to ask you tough questions. You can either answer them or you don't answer them. But it was a level playing field, and that was one of the things I took from it. I make no comment on my local experience, which I have very limited of before the Supreme Court. I mostly go to the ARC, as you know. So I loved the experience. I don't know about you, but I really enjoyed it.
Yeah, I mean, as I've said, I think not only you are heard for the merits of your case, and then you are presenting your case before, judges of the UK Supreme Court. So in terms of standard and expertise and knowledge, you're really dealing with la crème de la crème, as we say.
Indeed.
So, and they are, of course, much more knowledgeable than us, but there's much to learn by going before the judges there, definitely.
Yeah. And if I may, one other thing that I was warned about this, so I had prepared for it, that I enjoyed is that even though the end judgment, we're still waiting for our judgment in our case, will obviously limit itself, or may well limit itself, to the question asked before the board kind of takes a step back and looks at the whole picture, and there might be questions in there. In fact, there are a lot of questions in there that are not part of the record. And I appreciated that because it enables you as a lawyer to take a step back, because sometimes we're in our books, we know the law by heart, we know our case well, but sometimes it requires stepping back and looking at the bigger picture and to think outside the box and to think in a way not like a lawyer. And I think it enables you to look at the case from different angles that you perhaps wouldn't have if you were just simply, you're here with your record and that's all you have. I really enjoyed that too.
And I think one of the aspects of cases before the Privy Council which make a difference is that there's nobody else to review their judgment.
Yes.
So they take certain liberties,
Indeed,
which judges at the level of the Supreme Court or below would not be able to do, because they know they are, their decision can be appealed. So that, maybe sometimes lead to certain questions or decisions or comment that you probably wouldn't get before the Supreme Court.
Indeed. Last question for you, Anne-Sophie, and I don't know whether you have the answer to this, because we had briefly discussed it, and I know that you had mentioned that the changes that are happening are positive changes, but we are having the first budget of the new government soon. Is there anything in your wish list in terms of environmental law that you would still like to see, notwithstanding all the positive changes that we've seen?
No, that is too big a question.
If you had one wish.
No, I've got a PowerPoint presentation on all of this, and I'm going to start and speak for 25 minutes. No, I mean, honestly, I think, of course, the environmental law has to be. I think the topics are difficult. I think there are certain topics at the moment which are a bit sensitive, and I don't want to. I don't want at this point in time to take position. Okay. I'd rather keep my cards in my pocket.
Fair enough. In that case, I'll switch that to another question then, which is not related to environmental law. As you mentioned, you've been practicing law for a long time, both in the UK and in Mauritius. If you were to give one piece of advice to a young either an aspiring barrister or newly qualified barrister who is struggling because of all the challenges of practicing, being self-employed, someone who's not employed in a law firm, who doesn't have a structure, who's basically gone from studying to pupillage, where they were fairly mollycoddled, to, you're out in a concrete jungle, what advice would you have for them?
I think is Well, seize the opportunities for new work. I think as a junior lawyer, you don't have the luxury to be difficult with the type of cases you take, with the level of your fees. And I think everybody who has managed to stay beyond 15 years, at the bar would have gone through that. Sometimes, you take cases, and you are properly paid for it. Sometimes there are certain cases which are within your expertise, but which that if you're not, if you're pitching too high in terms of your fees, you might not get the work. If this is something that will help, further your career and have a good case on your CV, then don't be too difficult, because it's that experience and building your CV that will allow you to be known and to get, some better cases, better quality work, better clients as well. So not to be difficult, not to refuse to do things. I think at a junior, at all level, I think you have to be prepared to do. It's a question of attitude, I think. I think the problem is a lot about attitude.
Yes, and I'm always teasing the Gen Z and the Gen Alpha, which is the generation of our kids. But the less said about that, the better. Thank you so much for your time. Really appreciate it. And I suppose I will, when I post this episode, I will also put a link to the judgment. I think anyone, even a layperson, would be interested in reading the judgment.
Well, thanks for having me and giving a voice to environmental rights.
Thank you.
Thanks, Joanne.